And we're live. All right.
All right.
So it looks like it's delayed on my side, but I just have to work around that. I got the chat pulled up. Bill, how you doing, sir?
I'm doing well. Thank you so much for having me.
Man, I'm excited to have this conversation. There's been a lot that's been going on at the court level, the Supreme Court level. So I'm really interested in your
Well, and
analysis
I
on
think we
that.
ought to disclose something to the viewers, which is you and I routinely geek out together. We've had a lot of
True.
conversations about things. You pick my brain, I pick your brain about stuff. So this is not something that's going to be foreign to you and I. It's just everyone else is going to have to see the sausage be made now, I guess. Right?
And you had a birthday the other day, and I think you
I
said you
did.
turned 40. You turned 40.
I did. It was the 15th anniversary of my 40th birthday. So
Gotcha.
yeah, thank you
Well,
for that.
Happy birthday. Happy birthday. So let's talk about this real quick. So a lot of, what we've talked about is what's been going on at the Supreme Court level, and you
Right.
have the ATF that seems to be just overreaching. Not seems to be, they're overreaching continuously on what they're allowed to do from what it seems to me. And can you talk about, like, real briefly, like, how are they able to do that? Like, what gives them the power to be able to make all these rulings, and like, can we maybe start with that and then go into like some of these other
Sure.
things?
No, it's kind of, I guess we'll go back to our kind of schoolhouse rock, basic structures of government. So how can the ATF do this? The answer is they can't. And that is why they have been systematically shot down these last several months when you take a look at all of their rules. Now, the funny thing is that the Second Amendment has not been the saving grace in any one of these rulemaking orders. As a matter of fact, the court has never even so much as even really gotten into a Second Amendment analysis whatsoever, because it's not so much what the ATF was doing. The problem was how they were doing it, right? That's where the problem lies. So really, it comes back to, like I say, it's schoolhouse rock stuff. It's basic governmental functions. Okay, we got 3 branches of government, and there's the Article 1 branch, which is to pass all the laws. And again, if Congress wants to ban bump stocks, if Congress wants to delegate more authority to the ATF so they can regulate 80% lowers, or if Congress wants to expand the definition of what it means to be engaged in the business of being an FFL, they can do so. They can go ahead and pass laws, and there could be challenges to the constitutionality of that actual law, but we would never be able to challenge really the manner in which the law went into effect, because it would have been done through representative government, shockingly, exactly how we set things up back when we ratified our Constitution. Instead, what we're doing, and this is, although it's been used ad nauseum by this presidential administration, let us all remember that the genie was let out of the bottle in the previous presidential administration. Yeah. And it's where either they don't want to take on the task of trying to get Congress to pass gun laws, or Congress is too feckless to really do anything. Then what they do is they turn the ATF loose like some kind of attack dog, just let it get off the leash and say, hey, I want you to go in and just change the definition of things by reinterpreting stuff. That's what happened with the bump stock ban. The ATF had been on board with bump stocks forever. And suddenly there's a horrific shooting in Las Vegas. Congress likely could have acted, but whatever reason, the president at that time chose to just turn the ATF loose. First time that playbook was ever developed. It's been used over and over and over by the current presidential administration.
Yeah, and this is the danger of, this, what I call this political myopia, where when it's your guy in power, you're okay with, or I'm generalizing, but a lot of people, when it's their guy in power, they're okay with him doing executive orders or whatever. But then the danger of that is it's going to be abused by the other side, because it's being abused by that person. So we have a system in place for a reason, and it's separation of powers, checks and balances, and it's supposed to be slow and clunky, as far as I understand,
and a little ugly.
Yeah,
a little ugly. And again, let's go back. Let's take ourselves back in our time machine and go back to the time in which we were establishing our country. Okay, do we honestly think that we intended to create this massive administrative state in which one individual would be able to wield the power of the president across all of these regulatory agencies? Because that sounds awful lot like what it was that we had independence from, right? So I think that if the founding fathers could come back today and see the size of the federal government and see all the tasks that the federal government engages in, they would not even they would be like, what the hell is this? This is not what we established. I think that this Supreme Court has shown a willingness to try to strip some of that fat away, and let's get back to the foundational mechanisms by which this country was meant to be managed.
So we talked about some of these cases on the phone the other day, and I want you to go through them and how they are significant towards just general rights, and also how they're significant towards Second Amendment rights. And one of them is the NRA v. Vulu. Can you talk about that?
Yeah. So this is a case that people really need to, anytime the mainstream media wants to tell you about that renegade right-wing court, this is a unanimous decision, 9-0, in favor of the National Rifle Association. Okay. What this dealt with is the state of New York really essentially just wanted to kind of strong arm the NRA out of business there. And they went through their insurance commissioner and basically went to a lot of banks and things like that. And they're like, wow, we got a few complaints that we're investigating right now. But of course, if you guys just quit doing business with the NRA, they'll probably let these things just go aside. It was literally like something out of The Sopranos. And New York was very braggadocious about how they were doing it. Well, the NRA is engaged in commercial speech, and commercial speech is also protected by the First Amendment, as is all of these other companies that wanted to do business with the NRA, because it's a lucrative, they can be a lucrative client depending on what you're doing for the NRA. It's a huge organization, right? And so what the court came in, every justice, even Justice Brown Jackson, who's really shown to be the lightweight of the bench so far, but everyone agreed that that was a violation of the NRA's First Amendment rights of commercial free speech, as well as all the other institutions that had been affected by the state of New York. So huge win because it talks about how really government actors cannot be out there using the power of their office to persuade private industry. So for those people who live in states, my state, for example, where you have an attorney general that's far too politically active, the Rob Bontas of the world, the Kwame Raouls in Illinois, and the Letitia Jameses of New York and places like that. Yeah, this case should serve as a wake-up call to all of them. But again, you go search out that opinion, you'll never even see the Second Amendment even mentioned in it once.
Wow. Yeah, that's using that political power to try to influence and especially private business and private speech. That's really dangerous and very pernicious. It's a good thing that is being reined in.
Well, yeah, and this is you see this consistently from those on the left, which is that they will abuse any level of power that they have to try to suppress ideas, thoughts, or speech that is contrary to what they're feeding the people through the mainstream trough. And what I think everyone should really pay attention to this is those on the political right never call for those on the left to be canceled, shut up, to silence them. Candidly, we'll gladly let them keep talking. Okay.
Right.
The whole premise behind that TikTok account of Libs of TikTok is simply let's just let them show off what they're doing, right?
Absolutely.
But those on the left want to cancel our speech. Why is that? Well, that's because they recognize that if we're just going to get into a battle royale of facts and common sense, I can't win. Because if they could, they would let us keep talking, right?
Right.
So, but you really, for your viewers, if you're living in states with these really politically active attorney generals and they're going around like mob bosses, then this is a case that really is going to be very significant in reining them back in.
That's awesome. It's good to hear. Another one was the Cargill v. Garland. Can you talk about that one some too?
Yeah, that's the bump stock case. Okay. And so here's the thing. A lot of people are saying, oh, that's a huge Second Amendment opinion. No, it's not. Because once again, the Second Amendment's not even cited in the opinion. And then you and I, when we were geeking out a few days ago, I said this to you. I was like, hey, think about it. You think the Second Amendment even protects bump stocks? It's not a bearable arm.
Yeah.
It's not a bearable arm. I think a bump stock ban has zero Second Amendment implications. Zero. What the bump stock ban was struck down on was a piece of legislation that was written in 1946 called the Administrative Procedures Act. And the Administrative Procedures Act said, hey, listen, when administrative agencies are going to enact new rules, they have to do it within the confines of these legal requirements, and a failure to do so could invalidate the rule. And that's exactly what the United States Supreme Court did in the Cargill case. Do I think that bump stocks could be banned? I do. Do I think if they passed a piece of legislation, would it stick? I do. I think that and if you read even some of the opinions, they basically said it's not what you guys did, it's how you did it here that's the problem.
Yeah. That's, I mean, even something like a pistol grip, that's not a firearm. So I would assume if they went through the right process, they could try to ban
I think that's a good point, Taylor. I think it would come down to what is actually necessary for the function of the firearm. For example, like on a semi-automatic rifle, a pistol grip is kind of necessary to shoulder and hold the firearm correctly, okay, on a semi-automatic rifle. A bump stock is not necessary at all for the shooter to operate the firearm in any type of efficient or proficient manner.
Well, I was thinking about like with California and like those fins that they have to put on.
Yeah.
And if it,
but it still allows that shooting hand to rest on something to help stabilize the firearm. They just don't get, and I've never understood, like, does that suddenly make them less lethal or less?
Right.
I don't know.
And someone's like, who's about to go kill a bunch of people is like, well, I'm not going to shave off this fin because I don't want to add any additional charges to this.
I really want to shoot this place up right now. If I only had a real pistol grip on this thing, it'd be go time, right?
Yeah. Or like the magazine capacity bans, like it's really going to stop anyone. It's one of the easiest things to order of the gun in the mail or whatever to obtain. It's really going to stop them from
No, and every time you see gun violence crimes, I just did something on Twitter today about, it was a firearm that was, 2 youths got involved in a shootout. Okay, well, we already know they're youth, so they're underage, shouldn't be in possession of the firearm anyways. And then it's a Glock with a 17-round magazine and a Glock switch on it. Now, I thought we banned high-capacity magazines in this state a couple of years ago, and I'm sure as hell certain that we don't allow for Glock switches. So, but the problem is the lawful and responsible gun owner. So let's keep drafting legislation to go after them, right? They're the problem.
Exactly. Yeah. Well, speaking of dangerous people, let's talk about U.S. v. Rahimi.
Oh, that's a good segue. That's clever there. I like that. Really good. So this is the one case this year that actually dealt with the Second Amendment, where the ruling is deeply rooted within the Second Amendment. I think a lot of people thought that Rahimi had a lot more potential to it. But if you had carefully followed what had happened with Rahimi at the lower level, you realize that many of the big issues that could have been litigated here had been waived at lower levels, thus really kind of leaving us with a limited issue. And really the limited issue is do we as a nation have a historical tradition of allowing disarmament of people that we believe to be dangerous? And the answer emphatically is yes, we do. And I would have admitted to that and did on multiple videos of mine. In fact, I found a law, I think going back to like 1642 or 1649 from Virginia, which allowed to do it. Okay. Now, the criteria by which we were doing it back then is a little outdated, certainly.
Frowned upon.
Considerably, and for good reason. But the if a society believes that person to be dangerous, have we allowed the disarmament? The answer, according to Rahimi, is yes, it is. What the case never got to is this, and this is how I put it on one of my videos, is, okay, so you've said that the finish line is constitutional, that if they cross this line, we get to do this to them. Okay, what lane is constitutionally permissible to get us there? So, for example, when it comes to these civil protection order hearings, these civil anti-harassment order hearings, these red flag hearings, okay, extreme risk protection orders, they call them in some jurisdictions. Oftentimes there's a temporary order that's issued ex parte, which means one side goes into the court, makes a complaint, the other side has not even heard from, hey, here's the order, officers, go out and get these guys guns right away. Boom, this happens. Where's the procedural due process with that? And then when we get to a full-blown hearing, some states they're farcical in nature. It's just like they're going to submit pieces of paper, and whichever declaration the judge thinks is better wins. Well, I've been in the courtroom for 25 plus years now, and I can tell you it's hard to cross-examine a piece of paper. Okay, so you just can't attack the weight of the other side's evidence doing so. So if we're going to agree that dangerous people can be disarmed, fine, let's accept that an arguendo. What is the constitutionally permissible method to make that determination? What's the level of proof? What is the procedural due process that the person should be afforded so that they have a right to put on their own case? And those were never answered by Rahimi, and why I think we are a long, long way from ever really having a lot of these big issues resolved.
Yeah. Yeah,
Rahimi was you learn this like the first week in law school, which is bad facts will always make for bad law. Okay, and Rahimi was a terrible dude. I mean, there's just no doubt about it. Even only half the allegations against Rahimi were true. He's a terrible dude. He's the last person in the world that should be armed. So, and what I told a lot of people that were just shocked at this is when the Fifth Circuit threw that law out, the Supreme Court was pretty quick to accept review of it. Did we honestly think that the United States Supreme Court was accepting review to rubber stamp the Fifth Circuit? They didn't need to accept review to rubber stamp the Fifth. They could have just denied the petition, and the Fifth Circuit's ruling would have become the law then.
Yeah.
So when they took it, you had to know that they were at least in part going to overturn some of that decision.
Yeah, it's funny you say that, talking about Rahimi, because like I see these Second Amendment cases, and it's always this person that I'm just like, oh my gosh, this is not the poster boy for gun owners. Why can we not get someone? And I would hate for it to happen to someone who's a law-abiding citizen, but at the same time, it's like there are always these people that are just career criminals.
The least sympathetic plaintiffs you could possibly come
Yes.
Right.
I'm like, exactly that person probably shouldn't have a gun, but like, I guess. Yeah,
but we're gonna run him up the flagpole as the poster child for this issue, right?
Yeah.
because the constitutionally naive person, who is also oftentimes the constitutionally naive when it comes to the Second Amendment, their depth of analysis goes as far as, well, why should a dude like that have a gun? That's the depth of their analysis. So that's why, bad facts make for bad law. And this is a classic example of it. I still think there's a lot of things that can be done post Rahimi. We saw a bunch of cases today get GVR'd, which I know we're going to talk about in a minute, but it doesn't resolve the issue for nonviolent felons. You know, that dude who was in his 20s that got busted with an 8-ball of Coke at a nightclub one time, and now he's 50 years old and he's grown up, but suddenly he can't arm himself. Or like Mr. Range, 30-year-old food stamp fraud, right? Or how about the people who are using medicinal cannabis in states where that is lawful to do? Or how about people who are actually just using recreational cannabis in states like mine right here, where you don't have to have a reason to go to a weed store other than I just want to get high.
Yeah.
Okay. And yet, theoretically, a person who does that, they have to make the Hobson's choice. Do you want to preserve your life through a firearm, or you want to get high? Because you can't have both, legally speaking.
Yeah. So going back to how the ATF, kind of back up a little bit, we were talking about how the ATF has been given power to do all these things, even though they shouldn't, which, as far as I understand it, right, we know that Congress is they're the ones that make law, but they have delegated some level of discretion or authority to these federal agencies to not make law, but to write rulings and opinions that, by de facto, they kind of make law, right? It's like if we have words, if the laws are composed of words and all these words have definitions, and all of a sudden you change the definition of those words, you have either made or changed a law. So going back to that,
is this a segue to the next case we're going to talk about? Because if it is a fantastic segue you have done here.
It is
impressive.
Yes. So let's talk about Loper Bright Enterprise versus Raimondo, or whatever how you pronounce it. Yeah. And just like, this is like, and another thing with this, and I don't know if this is connected to this at all, but with suppressors, right? Suppressors are supposedly regulated under interstate commerce. But somehow when states say that, well, we're going to make this, we're going to source the materials, we're going to make them inside of our state, and it's not going to leave our state.
Right.
Somehow
Texas, Louisiana being
exactly. Somehow they still say that, well, no, we're still going to regulate that. So it's like there's these instances where it just seems like if you want to circumvent the Constitution, and like I can understand that that's what you're doing, that's one thing. But it seems like they're not even following the guidelines that they've set forth for how they're going to do it, and it just doesn't make any sense. But yeah, that was a long segue, but let's talk about that.
In the post-Bruin world, there are parts of the NFA that could be dismantled, and I think the first thing that could be removed from the NFA would be suppressors. I do. I honestly don't even think that it would be a situation. Well, here's why. The biggest reason is no one's going to tell you that they're dangerous and unusual. Right? They're clearly in common use. Okay. And while maybe back in the day in 1934 when we passed the National Firearms Act, maybe the mafia was using them, people use them now for hearing protection. Okay. And so I do believe that there's no historical analog that would keep suppressors within the NFA. Now, I think when we get to short barrel shotguns and some of the automatic weapons, I think we might have a little bit more problem trying to strip those back from the NFA. But yeah, you brought up a really good point. The entire national firearm, hell, the ATF in general was created as a division of the IRS. That's it. The ATF was created to go out and collect taxes on alcohol, tobacco, and firearms.
Yeah.
That's okay. Now, what's happened is for years and years, Congress and the courts were willing to say, God, we've created all these huge government agencies, and they're tasked with enforcing all of these regulatory laws within their particular industries. So let's just give them some more responsibility, and we'll just kind of let the fox guard the hen house. We'll let these administrative agencies actually interpret the meaning of the laws that we Congress passed. And sometimes they might even, just do a 180 as to how they interpret things. Never heard of that before, right? All right. Now, this has been going on for 40 plus years, and there was a legal doctrine called the Chevron Deference, and it comes from a case that dealt with oil spills and all kinds of environmental impacts involving, obviously, the Chevron Oil Company, okay? And what the court had ruled is that, listen, when we're taking a look at statutes which are governing particular industries where we have these regulatory agencies sitting over the top, we are going to allow them to interpret the meaning of these statutes, which literally allows the government agency to interpret the statute whichever way they so desire to achieve the outcome that they want. It's just that simple, right?
Yeah.
It's like Donald Trump picking up the phone one day and calling the ATF and saying, hey, bump stocks, make them illegal. Oh, we got a new opinion coming out today, right? And if you think it's bad with the ATF, deal with the FCC, deal with the SEC, deal with the FDA, deal with the CDC, deal with any of these EPA. Oh my God, the EPA, right? Any of these alphabet agencies. What Loper Bright did is the ruling went down the way I thought it would, but it went down on different reasons. I had told you when we were having a private conversation that, hey, they're going to throw the Chevron deference out based upon just simple constitutional structures of how our country's supposed
You absolutely called it too, or our phone call. I mean, called it exactly like it was.
I called it, but I was wrong about one thing, because I said it was going to be based on these simple constitutional framework arguments. What was it struck down on? It was struck down on the Administrative Procedure Act. Again,
that's right. Yeah.
Because Congress went back and what the court went back and they said, listen, Congress delegated this authority to you. You get to enforce these laws. It says right here you get to enforce these laws. Where the hell in here does it say you get to interpret these laws? It doesn't say anything in here about you. So you're acting outside the scope of the authority that Congress delegated you. So they made it a much cleaner bullet wound to it, really, in some ways. And that's what the Chevron deference was struck down. And what people don't realize is that is absolutely, positively the biggest ruling to come out of this session. Way, way bigger than Rahimi, because Rahimi didn't tell us anything new. And candidly, way bigger than the Trump immunity case. Because is anyone shocked that the Supreme Court gave some immunity to a president who acted in his official capacity?
No.
No. Of course, any president, even this current president, would have immunity for much of what he does while acting within his official capacity. So that ruling, I know there's people flipping out about it. That ruling, nobody stuck their neck out on that one.
Yeah. Yeah. And so with the Chevron deference, as far as I understand it and how it was used, and I'm going to recap a lot of things that you said, it's because with certain industries like oil and gas, for example, because that's what it was from, Chevron, the company. It's very technical. It's a very technical field. And so for Congress to stay abreast of all the advancements and everything that's going on, it's almost too much. And so they were like, well, these guys, the EPA, they're the subject matter experts. We'll let them decide because it's just too much for us to keep with. And it's just easier. It's more of a streamlined regulation process. Is that kind of the logic behind?
Well, I think what it was is it was Congress just not wanting to deal with it. Because I have no problem with Congress consulting with people within these agencies if they're trying to draft new legislation to make sure that the technical terms and the technology, right, that's all good. What they ended up doing, though, is allowing these agencies to say, hey, once Congress passes these laws, we're going to kind of decide what the words that Congress used means. Okay. And that's where the court went in and said, no, that's our job. That's our job. Congress never delegated any authority through the Administrative Procedure Act for agencies to go out and interpret the meaning of laws. Had they, then there could be a challenge under the separation of powers doctrine. It could certainly be. But again, it would be on what you're doing rather than how you did it.
Yeah, Congress basically just tried to make an additional branch of government by doing that.
Yeah. Congress got lazy. That's the bottom line. They get lazy. They want to take all of this work and they want to dump it off on somebody else. And why is that? Because it's impossible to hold a nameless, unelected bureaucrat accountable. You can always hold the politician accountable in the voting booth. But, you know, the director of this agency or the assistant director of enforcement of this agency, you don't even know who the hell all of these people are.
Yeah. Yeah, during those testimonies, which many people are probably familiar with, where you had like the ATF director or someone testifying, you had Congress asking them, these congressmen asking them questions. For me, it was always odd because I was like, you guys are the ones that gave, maybe not that congressman in particular, but it's like, you guys are the ones that gave them this authority in the first place. And now it's almost like this show of to the people. It always seemed like fake to me because it's like, just reel it in.
Yeah, there is no bigger waste of time, air, or space than any congressional hearing, period. Okay. All right. All it is a bunch of people who, they went to law school and got a law degree. None of them ever practiced law. I want to just puff their chest out and like, let me show you all what a great person, how great I am at cross-examining a witness. And they just suck at it. All of them suck, you know? So I almost have to not watch congressional hearings.
Do you think there's possibly going to be any unintended consequences from this Chevron deference case and like things that like I've had some people ask me questions about that and is it just cut and dry like no it should never be a thing or is it much more nuanced?
The minority, and I'm not going to roll my eyes at this. This is a legitimate concern. Are we going to overcongest the court system? Because now the courts are going to have to make all of these calls that otherwise administrative agencies would have. And does that ultimately then bog the court system down in its own weight where the administration of justice is adversely affected? That would be problematic. It clearly would be problematic. Now, again, that's speculation. It's speculation that's based on common sense numbers, but how that really works out or not remains to be seen. I think the other criticism, how can we expect judges to be experts on all of this stuff? That one is ridiculous because I'll tell you why. Judges aren't experts on firearms and they make rulings on that. Judges certainly are not experts on economics and they make rulings based on that.
Right.
They're not supposed to be political creatures and they make huge rulings on political issues. I don't know a single judge who's an environmental expert, but yet they will make rulings on environmental issues. So, that's just where they got to put their big boy and big girl pants on. And welcome to the United States Supreme Court. This is what you have court clerks for, and they will help you do your homework.
Yeah, it's just you have to adjust.
Right.
Well, let's talk about the ATF rule on the 80% lowers and how that is somehow not thrown out on Second Amendment grounds, but on, again, this Administrative Procedures Act, which just keeps coming up over and over again.
Yeah. And so this is the thing. It's like everybody, anytime you do a video, it's like, hey, let me just talk to you about what's happening in this screwed up state. Let's say you're doing a video about California. California's losing their mind again, right? Or which is I do that video about once a week. All right. And I get all these people like, I just wasted 9 minutes of my life watching your video. It's easy, shall not be infringed. And I really wish it were that easy. You wish it were that easy. Of course, we wouldn't have as much content to create in that situation, but it's not because when we take a look at everything that's happened to the ATF's rules, all of them, Second Amendment hasn't been the saving grace in any one of them. Not a one. As a matter of fact, when we get into things such as pistol braces, the Second Amendment even protect pistol braces? I don't know.
Really.
I mean,
it's hard to say.
Right off the page, like, well, of course it does, right? I asked you and you paused yourself, but like, oh, I don't know. And so that gives you an idea that there's going to be a lot more than just the Second Amendment protects you from what they do. Everything else protects you from how they do it. And that's sometimes the most effective argument. Okay. So
because it's almost like, okay, does the Second Amendment protect rifle slings? I mean,
probably considered an accoutrement. Right. So, but what we found with the rule on 80% lowers is that once again, Congress has delegated authority to the ATF that you get to regulate firearms. And then, shockingly, they have defined what is a firearm. Okay, it's a statutory definition. And it involves both the definition of what would be a completed firearm and various platforms of a completed firearm. And they've also further defined frames and receivers and how they fit within the definition of a firearm. And that clearly, absolutely, positively, the ATF has statutory authority to regulate that. When we get outside of the area of what's a frame or a receiver, and we're getting into now what's called chunks of aluminum, what the ATF did is they said, well, listen, when we're talking about frames and receivers that serve as firearms, we're going to reinterpret this law now. You see, we're going to say that really it kind of means anything that's in a fairly completed stage. So the definition would expand out to get all your 80% lowers and things like that. But they are absolutely positively, by definition, not firearms, not frames, not receivers. So where the court came down again is it's like, listen, under the Administrative Procedures Act, you have statutory authority to regulate firearms. You are now out trying to regulate chunks of aluminum. You have been given no authority to do so. And for that reason, the proper remedy is what's called vacator, which is the rule is thrown out and we act as though it never existed.
So let's talk about we'll take slings, for example. If someone wanted to ban slings, and I picked this because that's not a thing right now, but if someone wanted to, what process would it have to go through in order for them to ban slings? Like Congress just like passed a law like slings are illegal.
Write a statute.
Yep. Yeah.
And then again, that we could get into all sorts, but would the Second Amendment protect a sling? I don't believe so.
Yeah.
I mean, the Second Amendment protects all bearable arms that can be used either in offense or defense of oneself. And I just don't think a sling constitutes a bearable arm.
And how much of...
See, I think that, again,
is a barrel considered a bearable arm? Like at what point is...
I do, because I think that there's
that's required
there are obviously ancillary rights associated with certain components in order to make the right meaningful. So does the Second Amendment protect the right to have access to ammunition? Of course it does. Does the Second Amendment protect you to a barrel and access to triggers and things like that? Yes, all of which are absolutely essential for the functioning of the firearm. Can magazines as a whole be banned? Absolutely not, because to do so would render all semi-automatic handguns inoperable, right?
Right.
Or turn some into like single shots, whatever, right? So even the courts that have banned high-capacity magazines have acknowledged that we can't, as we see it right now, ban magazines altogether. Of course, then the question is where's the reasonable number? I know y'all right now are picking that it's 10, but what happens when California decides it's 3 next year?
Yeah, because it's always going to, I mean, slippery slope is real. They're always going to creep
it's a slippery slope, but it's a slope that we know what's at the bottom of the pit, which is complete civilian disarmament, because that's what they want.
Yeah. Yeah. So let's talk. And with the pistol braces, again, it was the same with
the pistol brace rule again.
APA, Administrative Procedures Act, or Administrative Procedures Act. Yeah.
They had a little bit more of a technical argument. Again, under the APA, it's called the logical outgrowth argument. I'm not going to bore your viewers with all of that, but once again, it came down to as simple as, well, Congress has defined what a rifle is. Congress has defined what a short barrel rifle is. Congress has given ATF a bunch of authority to regulate both of those in varying manners, whether it's a rifle or a short barrel rifle. We don't see any statutory authority here for you to suddenly reinterpret a pistol with an attached stabilizing brace, a rule that they had originally said, no problem, right? Advisory opinion, no problem. And then we're going to change our mind just like that. And that's the dangers. That is the dangers of when you turn this over to an executive agency, because that change can be made overnight. If Congress is going to want to change the law, hey, someone's going to have to introduce a bill, and then there's going to be hearings, and the public's going to get to comment, and there's going to be open debate about it, okay? And there's going to be open votes over the whole thing, and you can hold people accountable for how they voted on that issue. You know, that's the way we set it up. But just some nameless bureaucrat in office makes a phone call and says, I want you to write up a new advisory opinion and say, as of right now, bump stocks are illegal, unlawful. They're machine guns. That's what happened in one instance.
Yeah. Got a question here. Guardsman 134 asked, doesn't the Second Amendment cover furnishment? I thought that was part of the original version in the Bill of Rights and Responsibilities.
I believe that the Second Amendment would cover any necessary component to make the firearm functional. Yes.
Okay. Hope that answers your question. Next one, and this is one that I think affects a lot of people, even though they don't realize it affects them, and that is the ATF rule on FFL and what it means to be engaged in business.
Yeah. This is when I was doing the videos on this one, I was a little disappointed in the lack of views that I was getting. Not because I think I'm out there just doing amazingly great work or anything like that. It's that this to me was a rule that really could affect a lot of people in a horribly negative way.
Yeah.
Okay. Because there's a lot of people who get out on arms list and gun broker and all of that stuff. And, you know, sometimes you only have a budget for a collection of a certain size. Sometimes you only have enough real estate at your home for a collection of a certain size. So if you want to get something into the collection, you might have to sell something out of the collection. And there are millions of lawful, responsible Americans doing that every day. And what the purpose of this rule is to get everybody in the country under universal background checks, even though probably about 99% of all firearm transactions are subject to a universal background check already. But the rule used to be, hey, listen, if you're doing this and you're just dabbling a little bit, not a big deal. But if you're doing it predominantly as your form of business, then you are an FFL, you need to be licensed, okay? They watered that rule way down to basically say if one of the reasons you're doing it might be to earn profit, might be to attempt to earn profit, which means, as you know, listen, if you're selling a used gun on Gunbroker, you're not making any profit on it.
Right.
You're not
marginal.
Unless you got a collector's item or something like that. But if it's just it's an everyday carry that I don't need anymore, I'm going to sell it. Yeah, it's like selling a car, man. You're going to sell it for less than you bought it for.
Yeah.
Right.
And I've had several people ask me that are kind of trying to get into guns, and they've asked, are like, hey, I've heard someone's trying to sell something, and I'm like, hey, look, I'm not an attorney. I don't know this, but just keep in mind that I don't know what's going on with this ruling, but you might want to look into this before you purchase anything or make any sales, because
this is what I want your viewers to really understand about this rule. This rule has been enjoined under the Administrative Procedure Act again, okay? But this rule has only been enjoined for people who live in certain states or are members of certain organizations. And I can pull that list up, but I know it's like Louisiana, Texas, Mississippi, a large Second Amendment organization in Tennessee, and a couple of others, okay? So the rule's not enjoined for the whole country. So if you are a person who dabbles out there in gun broker or arms list, I really just want you to be really careful right now, because this is a rule that the ATF has a really bad history of enforcing a little too much. And if you don't believe me, what was the crime that Randy Weaver was accused of? Selling a shotgun with FFL, right? And then what did David Koresh? What was David Koresh brought down for, right? What did they say? Because he had all that weird stuff going on in there? No, it was because he'd sold firearms without being an FFL. And then Brian Manilowski, the guy who was the executive director there of that airport in Arkansas, that was the crime that killed him for. So, the ATF has a bad history of over-enforcing this rule. So I just brought all your viewers to just be really conscientious while the dust settles. And I'm not trying to squelch business on these platforms, because I think Arms List and Gun Broker and a lot of they do great work out there. They really do. But as the consumer out there, I'd be just a little leery. I think the ATF's out there scanning this stuff, and a lot of people are still living under the purview of this rule, which will ultimately be struck down because, once again, they've exceeded their statutory authority. Congress defined what an FFL is. Now the ATF wants to redefine it. So it's going to get struck down on Administrative Procedure Acts again, which means of all the things that we've talked about so far, Taylor, we've talked about the Second Amendment on one of them.
Mm-hmm. It's not as cut and dry as we'd like it to be.
As we want it to be, right?
Mm-hmm. Let's see. Guardsman commented, by that nature, a sling is a necessary component for the stowage for porter of a firearm, maybe port arms of a firearm. Therefore, a sling would in fact be covered.
Okay.
Maybe.
Depends
on what the courts decide on that.
Do not see the United States Supreme Court taking up a case on gunslings in the near future, though.
I'll have to take that video out of my
content
planning calendar.
Your shooting schedule, and pull that one out of the shooting schedule.
So let's see. I had some other questions here about. Yeah, let's go back to this interstate commerce and the suppressors, and I want to touch on that a little bit more. Again, how does that happen? It seems very clear cut. If the suppressor is made inside the state and it doesn't do any interstate commerce, then it shouldn't be regulated. But how in the world is it regulated?
Where's all the raw material come from?
Okay, so is that what it's?
Here's the thing. I think that if you had a situation where all the raw material, it's all mined, produced, everything, every molecule in that comes from that state, then there can be no, and it's only available to people in that state, right? Made in Texas, manufactured in Texas, material from Texas, only available to Texas residents.
Mm-hmm.
What is the interstate commerce at that point?
Mm-hmm.
But if you take a look at the Commerce Clause, and it's something you learn in law school, and it's the most boring crap you ever learn when you're there, because you're like, ooh, constitutional law. We're going to learn about the First Amendment. We're going to learn about the Fourth Amendment. This is going to be awesome. And then they start we're going to spend the first 2 weeks on the Commerce Clause. And you're like, what the heck is the Commerce Clause, man? And what it really is, it's the big, gigantic vacuum cleaner that allows the federal government to get their fingers in on anything that involves commerce crossing state lines, which, when you think about it, in the country that we live in, almost all forms of commerce cross state lines. Take a look at legalized cannabis. One of the ways that the states have been able to do what they do and avoid federal issues is what? It's all produced inside the state.
And only available to those in the state.
That's right. So in Washington's cannabis industry, which has been
a very lucrative industry for people. The marijuana is cultivated, grown, harvested, processed, everything in the state of Washington. It is sold exclusively inside the state of Washington. It is packaged inside the state of Washington. It never crosses our border in any direction legally. Okay. So that is what's allowed the feds to kind of leave it alone.
Mm-hmm.
If you had a bunch of Washington pot dealers start shipping their products to Idaho, oh, there'd be a big problem. There'd be a big problem then.
Yeah, that's interesting. So you think that if someone was able to do that, able to mine and ore the materials inside the state, but even then, it's like, how do you show and prove that?
I think suppressors could be removed from the NFA on just a basic, simple text and historical analysis on this. I really do. But if the courts were to be in a position of, well, no, this is still all about interstate commerce, then you just have to remove it from the interstate commerce question, don't you? If it no longer falls under the definition of interstate commerce, I don't know why we're talking about it anymore then.
How do you think it would be removed from the NFA? Like, what process do you think that have to go through? And how optimistic are you about that?
It would be a challenge to the constitutionality of 18 U.S.C. Section 922, Section whatever requires suppressors to be part of the NFA. You would challenge that individual section under a text and history challenge to whether or not it really survives the constitutional scrutiny. Mm-hmm. Which then, of course, we're going to go back and we're going to say, okay, well, the relevant historical period is the late 1700s. Some courts have said it might be in the 1860s. We didn't pass this law until 1934. We don't have any historical tradition of banning safety devices. Because really, when you think about it, what a suppressor truly is it makes a firearm safer. Mm-hmm. Right? So where's the historical tradition of banning things that make our firearms more user-friendly?
Right. Yeah, so, think about noise pollution, and which people think that's like grasping at straws, but no, it's real. Like if you have an area, all you
gotta do is be in a bay at an indoor range with some dude who decides he's going to run his 5.56 downrange at 25 yards, you know, on the indoor range, right? Because you'll understand how much you really would appreciate him having a can on that thing.
Exactly. Yeah. It's very strange. I mean, even like the manufacturer of a barrel with like an integrally suppressed barrel is somehow, it's like, do you know how they specify that? Like with a barrel or with any sort of muzzle device? Like, is there a certain level of decibels that has to drop the report of the gun?
No, actually, the federal definition of suppressor, and I know for a fact off the top of my head, the state of Washington, is anything which is intended to muffle or suppress the audible signature of a firearm. It does not talk about to a certain degree.
Mm-hmm. So even if someone made if you go from a muzzle brake to a flash hider,
if you make one out of a solvent trap,
I was going to say, even if you go from like a muzzle brake, I mean, it's like the concussion off of that is so severe, but then if you go to that to a birdcage style, it's just not as severe. So I mean, it's the whole thing is just wild. Again,
well, and this is one of the most challenging questions that people ask me all the time. It's like, hey, can you help me make sense of these gun laws? No, I can't help you make sense, because if you're looking for like this thread of common sense that runs through all of it, I mean, gun laws are written by people who know nothing about guns, have no appreciation for what they mean to our way of life, and they certainly have no understanding of how they operate.
Right. Yeah. Or how to take them apart.
How to take, you know. Because those Glocks are really hard to take down, man.
Gosh.
I mean, what was one of the biggest selling points of Glock when they first kind of blew up into the industry was how easy they were to take down, field strip, and clean.
Mm-hmm. The ATF said, "Hold my beer." We got a comment here. Suppression of a gunshot type device actually goes back quite a ways, historically speaking. However, laws regarding them are recent. Yeah, I mean, suppressors have been around for quite a while. I don't know how long, but
Well, we know they were around sometime before 1934. Otherwise, there would have been no need to ban them, right?
True. Yeah.
And they must have been quite prevalent for them to actually have the need to ban them. So I'm guessing somewhere, and yes, do I get that they became popular amongst the mafia? Yeah. Why do we think they became popular amongst the mafia, by the way? Probably to protect their own hearing.
Yeah.
Think about it. They're not walking around with plugs in like, hey, I got a whack job I got to do on this guy. I gotta get some eyes and ears real quick.
I don't want to disturb his neighbors.
Give me my eyes and ears. Let's go.
Does a blast shield count as a suppressor? Think about it. You're not hearing the full blast from the report.
I don't believe a blast shield would constitute. I mean, my gut instinct, I'd have to look into it a little bit more. I'd have to see the design of it, but to me, it doesn't. I mean, there's muzzle devices that clearly can alter the report of the firearm to some degree. I don't know how much muzzle devices can really quiet it. I think it's more of a directional thing and what the shooter experiences. I mean, a good muzzle device, the shooter's is just in nirvana. It's everyone left and right of them. Life sucks, right?
It's probably one of those things where it's like, yes, there's such, on some level we can create a gradient of like whether or not something reduces, but it's one of those things where you know it when you see it. Like
and what was it? You remember a few years ago, was it SIG that came up with some kind of internally suppressed like short barrel rifle or something like that? They had some really cool product and they were going to try to sell it, and the ATF stepped in and said, man, that's a suppressor on that thing. That's a Form 4 item. It was like an integrated suppressor into the barrel, though.
I don't remember that.
For the life of me, the name of it, and I only remember because I found it when I was doing research for one of my videos about suppressors at one point.
Yeah, I don't remember that.
The funny thing is the thing that actually got Washington Gun Law really going as a channel was suppressors. Well, it wasn't.
Oh, really?
No, it wasn't suppressors. It was solvent traps.
Oh, yeah.
Yeah.
I haven't looked into that recently. How is that one? Like the whole solvent trap thing. Have there been rulings on that?
Just kind of died down. I mean, I think that they raided some of the manufacturers. They sent nasty letters to people. A lot of people, disposed of it and stuff like that. And then it just seems like Operation Reticent Recall just went quiet. I don't believe that they're really going to round anyone up on this. Their beef, honestly, when I get critical of the ATF on my channel, I want everyone to understand that I'm critical of the leadership at the top. Okay. I'll be honest with you, Taylor. The agents that I've worked with at the street level are actually all really cool. Well, there's just one. I'm not going to mention them. But beyond that, the rest of them are super, super cool. And they were rolling their eyes during this whole forced reset trigger solvent trap stuff. They were like, Dad, I just want to get your guy's name off the list. This is not what I signed up to be in the ATF for. Okay. But the funny thing is I had done a video. Someone had said to me like, hey, Bill, can you do a video on what the laws and suppressors are in the state of Washington? So I was like, yeah. And even though I have a gun collection, I'd never really gotten into suppressors. So I geek out one night, do all the research, shoot the video. And then the next day, my Facebook page is just solvent trap, solvent trap, solvent trap, solvent trap. I'm getting all these solvent traps ads. And I'm like totally naive. I'm like, what's up with a solvent trap? I don't get it. So I started geeking out on solvent traps. And then I'm like, oh, I see what's going on here, right? So I did this video and I was like, hey, solvent traps, bad idea. Don't do it. ATF is going to get pissed about this. I'm telling you, don't do it. And the video didn't get a lot of views, but it got a lot of hate mail. I mean, my comments were like, yeah, screw you, Bill. Yes, this guy's probably a shill for the ATF, blah, 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 right? And one of the things I said in the video is, hey, listen, don't be surprised if you get a nasty letter or knock on the door a year from now. Well, fast forward about 9 months later, I get these alerts from YouTube that, hey, this video is just like blowing up. It's got like 30,000 views in a day. It's like, what the hell's going on? Well, unbeknownst to me, what had happened is that ATF had raided Diversified Machine. They got the shipping manifestos of everyone who bought solvent traps, and they sent them all nasty letters saying, hey, we think you have an unlawful suppressor. We need to talk to you. And when I did that first video of, hey, here's the do's and don'ts about talking to the ATF, and the biggest thing is don't talk to the ATF, let a lawyer do that for you. That was the first time I just had a video kind of boom, blow up on a national level. And I was like, oh,
Okay,
Wow.
so there's an audience for this.
Man. Yeah, that'd be a scary experience to get you know, a letter from them and be like, oh, what do I do?
Yeah, I know it is a scary experience, but then again, it's also an experience like, dude, when you were buying that solvent trap, what the hell did you think you were doing? Though, I mean, you kind of sometimes I get it where people they get burned, but it's like, man, you were playing with an awful lot of fire. I mean, why are you so surprised that you got burned here?
It's almost like it should be expected. Like you should have already processed that and been like, I'm aware of this possibly that's going to happen. And
and my deal is I just want everyone to understand where the lines are, and then they get to choose whether they're going to scribble inside or scribble outside. It's their life; they get to choose. And my job is just to say, hey, if you choose to scribble outside, and if you get caught, this is what could happen, and you do with that information as you wish.
Yeah, they should just start selling handguns as cordless hole punchers.
Cordless hole punchers. Yep.
Let's take a quick break. You good with that?
Yeah, I'm totally good with that.
Okay. I don't know how to do this. I'll figure it out. Okay, and we're back. I had the menu closed and I was like, oh crap, I don't know how to put us back up. Sorry guys, technical difficulties. All right. So let's see if we got any comments or questions. I think we had some.
And while you're
retarded.
pulling those up right now, just to let you know that we did just about an hour ago got a video out. So if your viewers want to kind of go over all the cases that were either accepted, denied, or GVR'd today out of the United States Supreme Court that might be relevant to our topics of discussion, I put a video up there that kind of goes over all of that.
Yeah, you guys go check that out after this one's over. I'm sure that's going to be excellent content. You're going to you said you're going to the GOA event in August.
I am going to the GOA thing. I'm actually, I'm going to reach out to Eric, president of GOA, and see if they can make me really, really busy because I got an attorney buddy back down in Knoxville he's an interesting cat, and it's one of those things that if I'm not really busy, he's gonna insist that we do lunch and dinner and this and blah 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 blah. And I'm like, so I'm gonna call Eric and I'll be like, dude, I'll work for you from sun up till sundown, man. I don't care. Just make me busy. But we're talking about me coming out your way too.
Mm-hmm. Yeah,
get out to the range with you, which would be really awesome.
I think we're gonna do a video on that.
Yeah.
I actually just thought of a question.
See how well a lawyer shoots a gun, right?
Yeah.
Yeah.
Something I don't know if we've talked about this before or if I asked you this on any of our other discussions, but I had a video where I talked about if you imagine arms along a continuum from like no arms at all on the far side all the way up to like, we'll say the infinity gauntlet for hypothetical sake, like something that you snap your fingers and it kills half the world's population. So if you make a continuum along that and you have everything that as its lethality increases along that continuum, where would you draw the line in terms of private ownership?
Well, I think the line has been drawn by the United States Supreme Court. We're all entitled to firearms which are in common use today for lawful purposes. Really that simple.
Mm-hmm.
The semi-automatic rifle is the most popular long gun on the planet right now. Certainly the most popular long gun in the United States of America. It is in common use. If you take a look at how many assault weapons, semi-automatic rifles are owned by Americans and how many are actually used in crimes, it is absolutely positively possessed for lawful purposes.
Mm-hmm. Yeah,
absolutely.
I mean, what does a semi-automatic rifle account for in an annual year in the amount of gun violence in this country? 1%?
Very low percentage.
I believe literally the ATF, or no, it was the Surgeon General, it was the damn Surgeon General's report on gun violence and the health issue in this country, flat out said that semi-automatic rifles account for 1% of the homicides in the United States and related to firearms on an annual basis.
Mm-hmm. Yeah.
So
yeah, I when I answered that question, I answered it slightly further to the lethality. Like I argued it in terms of whatever's individually issued to a soldier. To a modern soldier, and I based my reason on that.
Including automatic weapons?
Yes, including automatic.
Really? So you would be okay with civilians? I'm just asking an open-ended question here. You'd be okay with civilians having automatic weapons?
Mm-hmm. Yeah.
Okay.
And the reason I landed there was based on an idea that I came up with, which I coined it the combat vote. So the idea is basically like in a civil system, we have a civil vote where we vote and our vote is proportional and only counts for one, unless you're voting for certain parties, and then maybe it counts for more than one. But ideally, it only counts for one.
We vote often,
unless there's some mail-ins. But so get ready for that little disclaimer at the end of this YouTube video, at the bottom of this YouTube video.
Deniers, we're just having fun here.
So it only counts for one, and so in like a combat situation, be it a civil war or actual combat, each soldier or fighting person's combat vote is proportional to them, right? Like even in the military, a fighter pilot generally doesn't have the unilateral authority to drop a JDAM, right? It has to go through a certain chain of command process, and like they have troops on the ground that are lasering a target or whatever. But and again, this theory and where I landed it's not airtight. I'm not going to say it's airtight, but that's kind of where I landed, or philosophical way I went about answering that question was the idea of like a combat vote. And
so let me give you a legal angle on that, a historical angle on that may actually support your position. I don't know if I'm in agreement with that, but I will say that there could be a pretty good argument in favor of it, and that's this. If you go back and you take a look at historically, why did we have the Second Amendment? We had Second Amendment so that the citizens could form militias.
Mhm.
Okay, it's not exclusive. That's why the citizen is given the right to keep and bear arms.
Right.
And really, if you take a look at early Second Amendment views, it wasn't that we protected the right. It was you were expected to have a gun. In fact, if you didn't, it would be like, the hell's the matter with you?
Right.
And that gun would been something that would have been useful for militia service. And one would think, and you're a former soldier, I'm not, you're a former Marine, but I would assume that while going into a combat setting, a firearm with the most lethal capability would be the best tool to take with you. So is it entirely possible that our country's view of what the Second Amendment entailed is that we were absolutely given access to the most state-of-the-art, most lethal weapons imaginable at that time, because that is what was required of us as citizens? There is a plausible argument for that.
And this is also why I don't like it when the right, I'll say right, generalizing, says stuff like the AR-15 is, not that dangerous. It's nothing like the M16. It's nothing like the M4. It's not a weapon of war. I don't like the term, but right, like someone used that term. So, but it's like, no, it is. It's practically speaking the same as the M16 and M4, because the military almost never, not always never, but almost never uses the M16 or M4 in fully automatic or burst. Now, they don't use M16 anymore, but they use mainly M4s now. But they almost never. It's always semi-automatic fire. And so they're using M16s and M4s like AR-15s.
Correct me if I'm wrong. A lot of people think that the AR-15 is the civilian version of the M16, but in actual reality, historically speaking, the M16 is a militarized version of the civilian AR-15. Is that right?
So the AR-15, when it was initially created, was created for the well, I'm talking about back when it's designed by Eugene Stoner. It was designed for the military trials, and they even down to the round they picked, the 223. They initially used the .222, but then they went up to the 223. And I don't even know, but I'll get into like the details of why they did that. But part of it was it needed to penetrate a military helmet at 500 yards. But there's all these criteria. It had to be a certain weight, or like less than 7 pounds. Had to penetrate an enemy helmet at 500 yards and all these other things. But they created it. And the first M16s were stamped with AR-15.
Really?
You can find it, and anyone watching right now, go to Google, open up another tab and type in M16 stamped with AR-15, and it will literally have both of them on there. So yes, it's not like they had they designed this M16 military killing thing and all of a sudden like, well, we need to neuter this thing and make it for no, they designed it for the military. And just like Glock, for example, that was designed for the military.
Yeah. So let me ask you this too, because they make this big deal when you read like the Seventh Circuit. And the Seventh Circuit is like, well, this is really no different than the fully automatic M16. And I get that there are uses for fully automatic weapons in combat situations. But as I understand, talking to other former Marines and stuff, again, I don't understand this, so I'm relying on your expertise. The use of full auto fire has significantly decreased in military operations based upon research and what actually they find makes for better marksmanship. And that really beyond suppressive fire, there's not a lot of other usefulness for full auto fire. What's your experience? Because I mean, like I say, you've been
the military the military does train with fully automatic, but it's mainly for crew served weapons. So something like the M249 SAW or M240 Bravo or something like that. Those are what are called like crew served weapons, and those are like the belt fed, like you have a belt of ammunition, and those are used for suppressive fire. And there are instances where people have used the M16s or M4s in either a CQB type setting, or if they just have to use it for fully automatic. But
all hell's breaking loose, and it's just
the lion's share of cases over the past, as far as I understand it, the lion's share of cases over the past whatever 23-year war we had. I would argue that if you could go back in a time machine and replace all of the M16s and M4s with high quality AR-15s, the outcome would have been negligible. You still have the crew serve, right? Still have the crew serve belt-fed weapons.
Well, because that's necessary for the actual operations that you're engaging in, right?
Right, but it is. It bugs me when people say, "Well, you don't really have, the AR-15. It's not that dangerous. It's just a modern sporting rifle." It's like, okay, guys, the Second Amendment protects military-grade weapons, right? So you're creating a cognitive dissonance when you say that we need these types of weapons. We need these AR-15 weapons to suppress tyranny, but they're not military-grade weapons. It's like, oh, okay, well then they're not going to be very good at suppressing tyranny.
Mm-hmm.
And so it's this cognitive dissonance that gets created. It's like, just be honest about what it is and stop allowing one side to set the terms for the debate. And then you're like always back on your heels. Man, oh no, it's not that. It's like, no, just say, yeah, it is. Now that's not as PC.
Really, if you take a look like what Justice Thomas wrote today in denying the petitions on the Illinois assault weapon ban case, he basically said, hey, listen, I know the Seventh Circuit wants to make a big distinction between military and non-military weapons. Second Amendment doesn't make that distinction.
Mm-hmm. Right.
It doesn't. And you think about it. If the Second Amendment only protected non-military weapons, are you saying that we could pass federal legislation then to ban to disarm our military? So all the stuff that I get to own, that's protected by the Second Amendment. All the stuff you used as a Marine, okay, to fight for my country and our freedoms, apparently is not protected. That's how the Seventh Circuit sees things. So one would have thought that maybe the United States Supreme Court would have taken that case, but I'm going to let it percolate a little bit more.
Yeah. Let's talk about that too, and like how can you touch on the process for how something goes to the Supreme Court? Because I think a lot of people, I had one constitutional law class, but it's been a while, and just really briefly how that process works.
All of these Seventh Circuit cases were only decided by a 3-judge panel, and so they will go back and they will request en banc review from the full Seventh Circuit. I believe one of these cases had already done so, and that's been denied. If the Seventh Circuit were to completely deny each and every one of those cases an en banc review, at that point, those cases would be finalized and they would be more mature, like the Supreme Court would want them to be. I think what you're going to see in the Seventh Circuit is the same thing we saw with Duncan and Miller, the mag ban and the assault weapon ban out of California. It's going to go down, and they're just going to play games. They're just going to sit on it. They're just going to age it out like fine wine, hope that the Supreme Court changes its political complexion in the next few years. I think that the earliest that we'll see one of these cases back on potentially for the Supreme Court would be 2026 term now. I think the 2025 term is toast. I don't think we're getting any of them on there. On the video I did today, I pointed out that there's a case out here in Washington, which, by the way, has the coolest name ever for a case. So it'd be great to be the Supreme Court precedent. It's a magazine ban case that I've been involved in out here, that suddenly, with everything else getting sent back and knowing the gamesmanship that's going to be playing and knowing how I believe our state Supreme Court is very quick to just go ahead and rubber stamp this law, I actually think we got a case here in Washington called State of Washington versus Gators Guns. Isn't that a great name? Gators Guns. Because can you imagine if that's the precedent? According to the Gators Guns case, you can't do that. It's so awesome.
The only thing that could make it better would be if it was out of Florida.
Yeah, I know. It's out of Kelso, Washington. Okay, not far from Mount St. Helens, actually. And it was a guy who literally, once we passed the magazine ban, he was like, I don't care. And he wasn't like secretly selling magazines. I mean, he had bargain bins right there at his front desk, and he just threw 2 middle fingers to the state of Washington. But he did so in a county where we'd done our homework, and we had realized that, hey, that county went from 41% Republican to 58% Republican in just 3 election cycles. Okay. And all the judges had been voted in during those election cycles. So we had a feeling like, hey, the attorney general is going to bust them. He's going to sue them. He has to sue them in Cowlitz County. We'll countersue them in Cowlitz County and say, hey, this law that you're trying to sue them under, it's unconstitutional. And we did. And the judge enjoined the law. So we had what we were hoping was going to be a Freedom Week here in Washington State. Our Freedom Week lasted 88 minutes because a dude I went to law school with was sitting as a Supreme Court commissioner waiting for it. And the minute the judge issued the injunction, he issued a stay on the injunction. So all these gun stores, and I'd been telling everyone on the channel, hey, this is going to happen. This is going to happen. They had loaded up on this inventory.
Oh my gosh.
And they tried to blow as much of it out in 88 minutes before we got shut down again. That case, I honestly think by early 2025, we will have a final ruling from the Washington State Supreme Court. It will be a negative ruling. And at that point, I think that case sits in a really good spot to be accepted by the United States Supreme Court.
Wow.
So state of Washington, Gators guns.
And then what do you think the timeline on that would be once it has to go to the SCOTUS?
That would make it on the term for 2026 then.
Okay.
So yeah, if you're living in New York, Maryland, California, Washington, any other place that has an assault weapon ban, unless you have a radical change in your state legislature and they just do it the old-fashioned way through new legislation, yeah, you're stuck with this for a bit. And that also, Taylor, and this is the big, it's killing the small independent FFLs. It's killing them. Right? If you're the Bass Pro Shops and the Cabela's of the world, you got plenty of other crap to sell to make money. Okay. But if you're Joe's Guns serving some rural part of Indiana and it's a third generation family owned business and they just basically have taken a third of your inventory off your shelf. And it might be some of the stuff that actually has the most markup built to it.
I was gonna say, I bet the margin on those are much higher than firearms. Hardly have any margin.
No, that's the thing. People think that, oh, if you got a successful gun store, you're printing money. No, if you got a successful gun store, it just means you're not going bankrupt, because the gun stores run on almost the exact same business model as a grocery store. When you take a look at what a grocery store pays for inventory and what their markup is and their paper thin margins that they run, right? That's how. And so using the grocery store analogy, when you implement an assault weapon ban and a magazine ban, that's like walking into the Kroger's, or what do you got out in Tennessee? What's your big ones out there in Tennessee?
We go to Publix.
Okay. It's like walking into Publix and saying, hey, you got 15 aisles of really cool stuff here. We're going to forbid you from selling aisles 1 through 5, though.
We're going to ban the bread.
Yep. We're going to ban. Now, your rent's going to stay the same.
Only your high capacity bread, high calorie bread.
All high capacity, all assault bread. All assault bread. Right? So, I mean, but think about it. You take a third of the grocery store's inventory out there, but you leave their costs the same. Now, how are they gonna survive as a business?
I'm sure they care about that too, right? I'm sure they care about putting small business out of business, and yeah,
that's exactly what they're trying to do. You take a look at legislation like what we had passed out here in Washington, House Bill 2118, which was basically a codification of, see if I'm going to remember it, it's like California Penal Code 26806, I think is what it was. And this is one that requires 24-hour, 7-day-a-week video and audio surveillance inside an FFL store. Okay. And then all this video has to be stored for a period of time on a server that damn near is like what Amazon uses. The buildings have to be retrofitted to make sure that they're more secure, which could cost these people hundreds of thousands of dollars. And here's the thing, and we argued this in Olympia, there's no exception for a home-based FFL. Yeah. Wow. Which means I'm in a state that is now, effective July 1st of next year, will mandate 24-hour, 7-day-a-week audio and video surveillance inside a person's home because of the profession they have chosen. So when I sit there and I use terms like the People's Republic of Washington, I'm not too far off here.
That's not hyperbole.
It's not. No, it's not. And where I want like the viewers of you out there in Tennessee, okay, there was some crazy gun control legislation that was kicked around by, you guys got a couple of state representatives out there that are, they like to make a lot of noise. Now, the numbers in Tennessee right now were such that when that legislation was brought up, it was like, why don't you go outside and throw rocks at the moon? It's not going to happen in Tennessee, right? In the year 2024, it's not. But you got to watch it. You got to watch it. And right now, the secret is out about Tennessee's a little bit like my neighboring state over here, Idaho, right? The secret's out. It's a great place to live. And they let you live free like an American there. So your state's rapidly growing. And you've got to watch the way your state grows.
Yeah.
Okay, because I remember I grew up in Seattle, Washington. I remember when we were the biggest little city, and then all of a sudden, the tech industry blew up here in Seattle. The Microsofts and the Amazons and all of that just whoosh, and all the Californians came in. It was cool at first because they brought all their money, and so property values went up. All these new businesses, it was awesome. It became a big city, but they brought all their terrible politics with them, and now the product of that is where Washington is in the year 2024. So, folks in Tennessee, states like Georgia, states like Texas, Florida, states that are rapidly growing right now because they're providing a better lifestyle for their citizens. Don't change what you're doing, but just be very careful how you grow.
That's very true. It's very true. The talking about the Chevron deference again, one of the questions I had was, or a buddy had was, what do you think we'll say the other side is going to do? Like, it's hard to say other side on this one because it's not as clear cut as that. I mean, it's got like a lot of nuance in it, but in terms of the people that are maybe in favor of Chevron deference and they want to undermine the ruling, how do you see that going, or do you see that being possible?
Is there would have to be, if the Democrats controlled both the Senate and the House, they could start rewriting or amending the Administrative Procedure Act. They could start amending statutes and passing large omnibus bills and things like that would then statutorily provide more authority to these administrative agencies to start doing these functions. And there might be other challenges that could be made at that point. Again, going back more to the constitutional structural challenges that could be made, but the manner in which that would be implemented wouldn't be really subject to challenge then.
Okay.
So do I think that the Democrats want to get as much authority to the executive branch as possible? It seems that way, which is odd considering that they're worried that the potential future president might suddenly become a dictator. I'm not quite certain how that all reconciles, but don't let common sense get in the way of your arguments, right?
Yeah. Man, yeah. Talk about that a little bit. The one that happened yesterday with the immunity from official capacities.
Okay. So here's the thing. This is one of the most common questions that I get on my channel in the comment section. Can't we just sue these legislators for passing unconstitutional laws? Okay. And the answer is no, you can't. No, you can't, because they have immunity in their official capacities. Okay, especially when they're doing functions that are considered within the core functions of that office that they hold. And it's important that we have those immunities because, well, candidly, we could sue Joe Biden when he comes out of office for violation of the Alien and Sedition Acts. He's literally supported an invasion of our country. Alejandro Mayorkas right now could be charged with Alien and Sedition Acts.
He can certainly be charged with any statute for dereliction of duty, but he's immune to it. And it's important that we have those immunities because we cannot have a chilling effect on our elected leaders' ability to lead. You don't want a president saying, listen, I really think this is a bold step. We need to do it, but I'm afraid that if we do it, I'm going to get sued when I'm the ex-president. Okay? So for people to think that the Supreme Court handed to Donald Trump something that he didn't have prior to that ruling, no, they didn't. They basically said he's got immunity for all acts he conducted as president of the United States. I would expect the same thing if there was a similar challenge to Joe Biden's presidency or to Barack Obama's presidency, okay, or to George W. Bush's presidency, which was riddled with some decisions that were, in hindsight, very questionable decisions. Right?
Can you compare this and this type of immunity to something like qualified immunity that police have? And like, is it kind of the same thing or not?
It's very simple. It's again, if you are acting within the reasonable scope of your duties, and you can have oopsies, and you know that police officers sometimes have oopsies, right? How about the guy who gets taken in and booked over the weekend on a warrant? Turns out he didn't really actually have a warrant. You've heard that one happen, right? Now, did the cop act in a nefarious way? Was he just being a bad actor and was like, I don't care, throw him in the cannon? No, he justifiably relied upon records that he does in his normal course of duties, and he acted well within the scope of his employment.
In good faith.
He's subjected to civil liability for that. Even though his decision-making is questionable, right? Now, once we get outside the scope of our duties, like, for example, excessive force, your department, when you were law enforcement, you were authorized to use certain force depending on certain situations. You are also probably required to try to de-escalate before you use force. So if you're operating within the confines of your training and how you're supposed to do things and people end up getting injured, that's kind of one of those FAFO moments for them, right? But if you just take it from 0 to 60 like that, ignoring all of your de-escalation training and things like that, well, now that's how you could subject yourself to civil liability, because you're beginning to act outside the scope of your employment.
Yeah, and that makes sense. And it makes sense to me in that regard. And it also makes sense to me in the elected officials too, right? As long as you're acting in good faith, which I think that's the key here.
Yeah.
Within your official capacities, I think that you should be protected, right? Because when you talk about like, sovereign citizens, for example, they'll just like sue the heck out of police officers and sue the heck out of other people and hold liens against their house. Like, and it creates such a almost like a tyranny of paperwork and administrative things that occur. However, when talking about the politicians, right? So if we have a politician who decides I'm going to try to pass a bill to make it illegal to say certain things. And let's say this bill is a clear violation of the First Amendment, right? Like, yes, okay, let's say that even though this person goes through the correct channels to try to pass this bill, I still feel like on some level it should be like, okay, you may be acting in your official capacity, but you're clearly doing something that is a violation. Just like as a police officer, if I were to violate someone's Fourth Amendment right, I would be held accountable.
Yeah,
if I were to do a certain seizure.
Legislation that says in the town square, any statement that is Islamic in nature is totally okay, but anything that is Christian in nature, no bueno. That is a crime to go out in prison. So you are absolutely endorsing one religious belief in at the expense of another. Clear violation of the First Amendment, right?
So if a politician does that though, and they try to do that, there's not, as far as I'm aware, any consequence.
November, there is
elections.
Yeah, and of course that would then depend on having a educated electorate. Okay, and we clearly do not have an educated electorate. I think we struggled with an educated electorate 30 years ago. I think social media has made the electorate way dumber.
Yeah. I also think
less informed. That's what I should say. I don't think they're dumber, but they are certainly far less informed.
Yeah. Well, and I think I said this before. I may have been with you, but I feel like tax day should be the day before election day. And not only that, but I think that this whole thing where you work for an employer and they automatically take out a certain amount of your taxes and you never see it, I don't think that should be a thing. I think just like with small business owners, you should have to, you yourself, take out a certain amount and then go hand either a check or hard cash to the tax office the day before election day.
Would you call yourself a conservative, or would you say you're more libertarian?
I'm more libertarian leaning.
I've noticed that, and because I've noticed there's what I appreciate about it, though, is there's a consistency to your positions. As you've articulated your positions today, there is a real level of consistency, and the consistency is I want government and big business out of people's lives.
And I still acknowledge that there's a need for government. I still acknowledge there's a need for government, even government regulation, right? Like even when people tell me they can't,
we need speed limits and crap like that.
Right. Yes. Well, everyone hates government regulations until they drive under a bridge that collapsed, right? Like it's like there a certain level of regulation have gone into ensuring that the type of concrete they use, the type of reinforcement they use, the engineers that are
that have the
certifications, exactly. So yes, I mean it's not full blown libertarian. I don't know what you would call it, but
that you understand that government has a need for certain core functions. There are core functions that we all do rely in a civilized society of having government do. Beyond that, that's where government needs to stop. And what we're living in is a society now where I think a lot of politicians have completely lost faith in the individual. That somehow or another, the individual is incapable of governing themselves. For some reason, the individual we should just insulate them from the accountability of their own choices. And I think we're people like you and I that are a little bit more libertarian is like, no, I think every individual has the absolute right to their own manifest destiny. And maybe they succeed, maybe they fail, and most of us will find a combination of the two.
Yeah.
Right?
Yeah.
But it's we have to control our own destiny.
Yeah. I completely agree. Well, man, this has been awesome.
This has been fun. This is a good geek out session, man.
Yeah.
And I do get to come out there and shoot with you in August, right?
Yeah, absolutely. Absolutely.
It's gonna be awesome.
We'll make a video out of it.
Yeah. We'll try to get some content. You'll be like, we'll see if a lawyer can shoot.
I see. I think you'll be all right. I think you'll be all right.
No, actually, there's funny. I did a video with this FFL over in Moses Lake last year because they're one of the challenges to our assault weapon ban. It's a case called State of Washington versus Guardian Arms. And so one of the main trainers over there took me out to the range just to go play around. He had a bunch of stuff he wanted to show off. And apparently he was doing a video about it, and he'd been talking smack early in the video, like, yeah, we're going to take the lawyer out to the range.
Oh, my gosh.
So, listen, I know I don't pull the trigger as good as a former Marine and law enforcement officer, but I've actually done a lot of training. I've done a ton of practice. During the pandemic, I was so bored that I was, and I had stocked up pre-pandemic on ammo. I'd so stocked up that I was at one point doing about 600 rounds a week.
That's quite a bit of training, much more than most people do. That's a good amount of training.
I was making YouTube videos and running to the range and throwing lead down range all the time. That's all I did with my life.
Dude, yeah, that'll be fun. Before we get off, point your viewers real quick to some of the videos you've done recently in your channel and where you can find you. I mean, they know where they can find you.
Yeah, no, well,
Washington Gun Law.
It's pretty easy. But like I say, today's, we got 2 videos out today. First is about some new laws that went into effect in California. I always look out for my good folks down in California. I think we should all watch California because that's where the crazy starts, and it will spread to your states if you're not careful.
Yeah. That's what we call foreshadowing.
Yeah, exactly. New ammunition tax went into effect July 1, 11% on all guns, gun accessories, and ammunition. All goes to gun violence prevention programs, which when you're in a state like California actually equates to civilian disarmament. And then the other video today was kind of a rehash of all the cases that either got rejected or GVR'd, granted, vacated, and remanded back down to the Supreme Court. And then yesterday's two videos yesterday, one is an interesting one that talks about how Rahimi really didn't change a damn thing. Didn't even answer a question for us. And the other one is for folks in my state. We've had 40 new gun laws passed in Washington state in the last 6 legislative sessions. 40 new gun laws. And we now rank as the 8th most dangerous state in the United States. And when it comes to active shooting situations, we actually were tied for 2nd. And we have set the all-time record for homicides each of the last 3 years. So the video is really like, hey, how well those gun laws working here in Washington?
Yeah. Wow. Well, guys, go check him out. Bill, thank you so much for coming on the show. This has been great. Looking forward to.
Well, let me put a plug in for you because hopefully I got some viewers that I told them to come over here. But I've been geeking out on your channel. You're doing really good work. So I encourage all my viewers to subscribe here. This is a good channel. You're going to learn a lot. You put a lot of effort into your videos too. I was talking to you off air. I was like, man, you spend a lot of time editing your stuff. So it looks good. Keep up the good work, man. You're doing God's work.
Thank you. I appreciate it, man. I appreciate it. Well, guys, thank you so much for watching. And Bill, thanks again for coming on the show. And as always, train to a higher standard.